here we want to bring into the conversation, of course, our friends, legal analyst Randy Zellen and legal analyst William Trackman as well. They joined me. Gentlemen, thanks for being with us. We've talked about this so extensively. We're finally in the deliberation mode here. Day one wrapped up. They went about over 4 hours. They're going to be back tomorrow. Randy, I'm going to start with you, though. If a jury sends a couple notes to the judge, does that mean deliberations are going well, or are they confused? If they want to revisit testimony from the very first witness going back weeks, does that mean they forgot what the testimony says? Does that mean they want a clarification of the testimony? Does that mean there's some type of, intractable progress at play here? How are we to read these tea leaves?
I'm glad that I got it out of my system before we went on air. William and I, he allowed me to go on that edge of the cliff and, okay, so what do we think about the notes? It's impossible. Try enough cases, and when you think you have it right, I could sit here and tell you, oh, it's good for the prosecution because they're looking at David Pecker, and David Pecker doesn't have the baggage that Michael Cohen has. And they are looking to see what David Pecker might have been able to share to get them into the brain of the former president, to look for that knowledge and to see what his intentions were. Maybe they're looking to corroborate the things that Michael Cohen said, or you could be, hey, this is good for the defense because David Pecker made it sound like catch and kill is legal. David Pecker made it sound like this is something that happens and it's really not a big deal. So I think the short answer is, who the hell knows?
Okay. William, to that point, the jury had these 4 requests in the first note. So I wanted to hear, like Randy said, David Pecker's testimony regarding this August 2015 Trump Tower meeting where he agreed to identify negative stories for Trump, a phone call that he says he had with Trump about the Karen McDougal deal, and his decision not to sell the rights to McDougal's story to Trump, known as these life rights. And then the jury also wanted to hear Michael Cohen's testimony about the same Trump Tower meeting there. When we're just talking about the first note on just day one of deliberations, I mean, there could be many notes in day 2 or possibly 3 or 4 of deliberations, right, William? That's how this goes, too.
Oh, yeah. I mean, you could have 15, 20 notes by the end of it. The thing that is good for the defense is that the jury isn't trying to convict right away. So they're at least taking some responsibility for the solemnity of their obligations as members of the community and members of a jury, and deciding they ought to look at the evidence more thoroughly and more closely. So that's good. I mean, the worst case scenario for the defense was a conviction today. That's not going to happen, obviously. Probably won't happen tomorrow either, because they are at least going through the paces of looking at some of the evidence. Now, I agree with my esteemed colleague, Randy. It's hard to speculate about what that means. It does seem like they might be trying to piece together a few things to compare witnesses across witnesses about what they testify to. So that could, again, be about credibility. It could be about how much they believe one witness over the other. All in all, who's to say? But the key is that for the defense, it's not over yet. There's definitely either a possibility of acquittal or a hung jury.
All right, gentlemen, I want to read this because I've been grappling with it all day, and this is what makes this whole trial so confusing. These 34 counts of falsifying business records that Alvin Bragg and his team have, tried to elevate into felonies here, into the furtherance of another crime while they were either concealed or committed here. So our producers, with this clarification, and I think it's important, I'm going to read it. So, Trump is being charged with a felony because Bragg, who was in the courtroom today, might we add, alleges he falsified business records in furtherance of a separate crime. They say the separate crime is a violation of New York election law, which makes it a crime to, quote, promote or prevent the election of any person to a public office by, quote, unquote, and this is bold, unlawful means. So to satisfy the unlawful means element of that crime, the DA put forth 3 possibilities. I'm going to read them here. 1, a federal campaign violation. 2, the creation of additional false records. Or 3, a tax law violation here. So Randy and William, all throughout the duration of this trial, I've been asking you, what other crime What was the in furtherance of the crime? What was that crime? How can you commit a crime in furtherance of another crime without being charged with that crime? Does that make sense, Randy? You?
No. Do you want me to keep going?
Sure.
Okay. I have used the word unprecedented probably an unprecedented amount of times.
Okay.
And just when I think I've seen everything, this jury instruction comes in. And I've tried a couple of cases in my 36 years of doing this. I have never, ever been confronted with a case where, first of all, throughout the trial, the defendant doesn't really know what the other crime is. It's not indicated in the indictment.
Until the very first day of jury instruction, Randy. Until the very first day.
It's not spoken about during the trial. It's mentioned for the first time in the prosecution's closing argument, which is not even evidence. And now suddenly this jury is given a poo-poo platter. You can pick from this one, or you can pick from that one, or this one, and you don't all have to agree.
Yeah.
4 of you can think that it's a state tax crime. 4 of you can think it's a federal election law crime. 4 of you can think that it's a state election law crime. You might as well just say, forget it, and let's just send it to the appellate division and let them toss the conviction.
Okay, so William, to that point, the jury instructions state the jury, to Randy's point, does not have to unanimously agree with each other on which of those 3 unlawful activities Trump intended to do. But the jury does have to be unanimous that Trump intended to do at least one of those unlawful activities, even if they don't agree on which one here. This kind of menu of unlawful activities. I'm going to repeat them again. 1, federal campaign violation. 2, creation of additional false records. 3, tax law violation. Some have described this as legal acrobatics, legal jujitsu here. But does something like this open up Judge Juan Merchan, open up DA Bragg and his team to problems at the appellate level? If you are saying to the jury, this is what we mean by in the furtherance of another crime, take your pick. William.
You know, one of the most important principles that the Supreme Court has announced in criminal trials is that you want a unanimous jury, a jury of your peers to pass on your guilt. And here it sounds like a mix and match exercise where the jury is allowed to say, well, some of us think it's a campaign violation. A few of us think it's a tax problem. But at the end of the day, we all think that something was wrong that was a predicate for the payment, the hush money payment. And so we've cobbled together a unanimous verdict of 12 based on our, combined mix and match exercise. I don't think that's likely to happen, but it is unprecedented and it's highly questionable. I've never heard of a situation where a jury is allowed to mix and match predicate crimes in order to get a conviction on an even higher level crime. Imagine a conspiracy charge, with a criminal racketeering charge, and you would say, "Oh, jury, you can choose between one of 5 things that we would establish the conspiracy with. You don't have to agree; just mix and match what you want." Very unprecedented, very unusual, and I think there is an appellate issue.
Okay, Randy, why, or maybe this is an option, and correct me if I'm wrong here, couldn't the jury just ultimately decide on the misdemeanor question with the 34 counts? Couldn't they just be put to that?
Technically, yes, except the statute of limitations on the misdemeanor expired a long time ago.
So that's not an option for him to be found guilty on the misdemeanors because of the statute. That's why the federal furtherance is in play.
I guess if that's what, and I'm not certain that is even on the table for them. It would have to be treated as a lesser included offense, and I don't recall anything in the instructions where the jury was instructed on the misdemeanor of making that a false entry. So I don't think that's on the table right now. But if it were, the judge would be duty bound to toss that verdict because the statute of limitations is gone.
Yeah. William, if you're the jury foreperson or a member of the jury and you request to see and revisit, some of the testimony from witnesses during the duration of the trial, why in New York does Judge Merchan have to read it out, parts of the testimony that want to be revisited? Why can't they just take a transcript, go back into the room and read it?
Yeah, well, you're seeing this debate between the prosecution and the defense about what's realistic in terms of how much to read out. As it takes time, it's laborious. Here, that's the procedure that the court uses here. Oftentimes, the jurors will just get a transcript of what happened. Here, that's not enough. There actually has to be a readout of the transcript. Here, I think that if you're the foreperson of the jury, you have to know that juries are renowned for reaching movement right before a weekend, and here we are on Wednesday. So I wouldn't be surprised if a lot happens between now and Friday afternoon. In terms of movement. That doesn't mean a verdict necessarily, but I do expect something to happen. That could be a notification to the judge that they're hung, that they need even more evidence, that they're going to have to really dig into something else entirely besides the notes we've seen today. But I do expect there to be movement as opposed to what we have right now, which is a lot of reading the tea leaves. And so those elements will make themselves clear over the next 2 days.
Randy, for viewers who aren't familiar with the jury deliberations, and I have admittedly not been on a jury myself. I don't know if you have, but you've been in courtrooms with juries, the both of you. What are the deliberations like? If there's a majority in favor of some way, and then there's a minority in the opposite view, does the majority have to convince the minority to get on the same page so we can be unanimous here? And who leads that effort in the room?
Well, I think, and I've never been in there, though. I was once involved in a fictional trial where we actually got to watch the jurors deliberate. But having spoken to jurors after trials and having read transcripts on at least one occasion where a verdict was overturned, what typically happens is they'll get in there, and after a short period of time, they'll take a straw vote just to see where everybody stands. Show of hands, guilty, not guilty, don't have any thoughts yet. And then the personalities will begin to rise. The talkers, the speakers, the leaders will begin to make themselves known, and they will speak up or maybe ask other people, what's your opinion? What's your thought? How do you feel about this? And it kind of organically grows. You'll have one side probably taking a more strident position, but you may have that one wild card, and don't be surprised if the defense went out of its way to pick that one wild card, that one person that they can count on to be Dr. No. No matter what, I don't care. I don't go with the herd. I go my own way. And if you're all voting to convict, I'm not doing it.
William, though, we know there are two lawyers amongst the jurors, jurors 3 and 7. They're lawyers. If you're Trump's defense team, if you're Todd Blanche, is that an asset or a liability to your case?
Probably a liability, just to be honest. If you're an attorney in New York, you're probably on the left. You probably understand the consequences of what you're doing. You're probably able to exert authority over your colleagues in that context and say, look, I understand the judge's instructions better than everyone else in the room. I understand the law, I understand the facts, how they apply to the law. And so I do think there's a danger of attorneys basically vouching for the fact that Trump is guilty. On the other hand, you have laymen who I think are more likely to question Michael Cohen's credibility, the whole prosecution in general, and to say something's not right here. And so I think the laymen are actually probably better for Trump than the lawyers are. So there is a danger, and they knew this during voir dire, the jury selection process, that attorneys can have an outsized influence on jury pools. And even if there is a hung jury, which is, a likely possibility in my mind, there's going to be a count. We're going to figure out how many jurors went one way, how many jurors went another way. That's going to affect the media. It's going to affect the prosecution's decision as to whether to recharge. So we're still a long way from the end here.
And Andrew, I must say, and I love William's analysis, but it strikes the opposite for me. I think here, one lawyer, particularly someone who is a self-proclaimed, I think, trial lawyer or litigator, I think it could actually be a benefit to the defense, because I know if I were a lawyer listening to that jury instruction, even if all I've ever done criminally is watch Law and Order, I'm like, wait a second, I have never heard of such a thing. And maybe I do start to wonder, is this law fair? Is this weaponization of the justice system? Maybe this judge that I feel so close to there's something not sitting right with me, and it may very well be that the lawyer becomes the focal point of, guys, I got to tell you, this doesn't feel right to me.
Yeah. You know, without getting too much into the weeds, because I think it's interesting, the case in point, to juxtapose this with what happened with Harvey Weinstein, who got his conviction overturned. In that case, the reason it was overturned was because the appellate court realized and ruled on the fact that the judge in the case allowed for too much that the prosecution wanted. Could we see something similar happen here, Randy?
Absolutely. Starting with Stormy Daniels, why in God's name do we need to know if the former president wore a condom in a case like this? Continuing on with the rulings that the judge made in terms of what the former president could be subject to on cross-examination. We saw that very same thing in Harvey Weinstein, where it was like, Judge, you deprived me of my right to make an intelligent decision as to whether or not I wanted to take the stand because you were exposing me to a cross-examination that I didn't deserve and was not warranted. Karen McDougal, that this is an uncharged bad act. And here, one of the first notes, the jury wants to hear more about Karen McDougal. So we are well on our way. If there is a conviction, as William said earlier, a whole host of appellate issues.
I see.
And now we're seeing the one of, you just let way too much in.
Okay. All right. So, William, just lastly here, it seems like you're leading, and let's make predictions, shall we? It seems like you're leading to a hung jury. Randy, what are you leaning to? I know we're just the end of day one of deliberations, but we don't know how long they could deliberate. It could be wrapped up by tomorrow. You just don't know. I want to get your predictions on the record. Randy.
A week from Friday, hung jury.
A week from Friday, hung jury. Okay. And if it's a hung jury, what happens to Donald Trump?
Well, aside from, I don't know if he drinks, but there's going to be a lot of celebrating and a lot of rallies, and let's hope things don't get too violent and too out of hand. And I think the next thing that will happen is that there will be a motion to toss Judge Merchan from the retrial.
Okay, we'll have to leave it at that. Randy Zell, William Trackman, always fun to talk history in the making. Gentlemen, we'll see you soon.
Thanks, Andrew.